Yeah, I just made that up in my head, but I still think no, I don't. I was gonna say I still think it's better than what the defense has done, but no, not so far. So far, it's still boring. Boring socks. Hopefully, we'll get to the murder soon. Any day now, we're gonna get to the murder. Well, any day now, we're gonna get to Furman. So that ought to be bleeping interesting, right? There's gonna be a lot of bleeps that day. You're gonna be bleeping sick of bleeps. I'm actually gonna record myself saying bleep, and that's the bleep I'm gonna use. No, I'm not. That'll be just awful. I see the loopy thing is on, and our playback speed is correct.
Speaker time. All right, ladies and gentlemen, we're going to take our mid-afternoon recess at this time. Remember, all my admonitions to you will be in recess for about 15 minutes. All right, Agent March, you can step down. You're ordered to come back in 15
Of course.
minutes. Thank you.
Of course. He's going on break. Of course. Start the day off looking at that seal. Beautiful seal. We don't
Dad,
see
it's
it
too late
enough.
to change the label, so I penciled it in.
That was a mistake, wasn't it?
I don't know if I'd call it a mistake. I just wasn't paying attention. I guess you could call it a mistake.
Did you check the sample afterwards to make sure that you had labeled it properly when you changed the labeling?
Well, I knew that's the sample that I had run. I just didn't label it properly.
You knew at the time that you hadn't labeled it properly?
After the run, I did.
And you knew after the run because you just looked at the chart.
No, that's not true at all.
How'd you figure it out?
Because I knew which sample I ran. I told you, you label the chart. I changed the run number. You have to change the run number. It doesn't automatically change the sample. You have to change that also. In this case, I didn't change the sample.
What was the time difference between that run and the one right before it?
3 minutes.
And you changed the label each 3 minutes as they're going through the system?
Yes. There's a lot to do in that 3 minutes, and I made a mistake in that 3 minute time period.
Now, yesterday you were asked questions about the dress. Do you remember that?
Yes,
And you said that you detected EDTA on the dress.
that's correct.
And the difference between the EDTA or the EDTA-like substance on the dress and the evidence was the presence of the 132 ion, correct?
Well, I got the full daughter spectrum, yes. The 132 ion is part of the full daughter.
And you indicated, I believe yesterday, that you would not identify the 132 daughter ion unless its signal was 3 times higher than the noise. Remember that?
I said that's what people like to look for, 3 times the noise for identification of a signal, yes.
May I mark another chart?
Yes, defense 1273. And what is this, Mr. Glazier?
This is a chart labeled control for dress, or K65 dress.
Thank you. This is Robertson 1273. All right.
Agent Mark, let me show you 1273 and ask if that's the full daughter spectrum, or the full spectrum for the control for the dress.
Yes, that is.
Show this on the envelope, please. Agent Marks, you see numerous spikes. Let me cover up the top part to illustrate that. In the bottom area, going all the way along the bottom axis.
Yes.
Is that noise?
Yes.
Now let's look at the 132 ion. It's not much higher than the noise, is it?
No, it's not.
So your standard of 3 times, you didn't apply it here.
But if you remember in my report, I said it was detected. I did not identify the EDTA in this sample, and that's why I said it was detected and not identified. I used that because I wasn't comfortable identifying it to the exclusion of all other chemicals, but I thought I had enough there to say it was detected.
You testified here that you think that's EDTA, correct?
I believe that it probably is.
And the reason that you will not say that the evidence is EDTA is because you couldn't identify the daughter spectrum, right?
Yes.
All right, let's compare this to the full spectrum that you did on the gate stain. Do you have that chart with you? The chart that corresponds to this chart that's on the screen.
Any way I can help
I
you,
don't have one
Bobby,
that
I
corresponds
will.
to that because there was no spectrum to print out.
Let's look at the one for the sock. That corresponds to this chart for the dress.
I don't have that one also because there was no spectrum to print out.
So you didn't print out any results at all, like you did for the dress.
No, there was nothing to print out.
So, and that data's been destroyed, hasn't it?
Yes.
So we cannot look at your chart that you did on the back gate and the sock to see whether the 132 iron is really there, can we?
Yes, you can look at the RICs that I provided.
With a chart like this is the full spectrum, isn't it?
Yes, it is.
We don't have a chart like this for the gate or the sock, do we? Because you destroyed the data and you never printed out the report.
I looked at the chromatogram, and it did not show EDTA present, and I didn't print it out. There was nothing to print out. It was all noise.
But you have nothing to show us that demonstrates that.
Yes, I do. I have the RIC chromatogram, which shows that there is no signal.
Well, that's the one that shows that the 160 disappeared also, isn't
Well,
it?
I mean, if you look back, I probably have the RIC for the dress. Let's see if I have it.
You don't want to admit that there's EDTA on the back gate and the sock because it hurts the prosecution, do you?
No.
The question and answer stricken juries to disregard his argument.
Now, Agent March, you testified that your basis for estimating the quantity of blood in the evidence that you started with was looking at it, correct?
Yes.
You did no analytical method whatsoever to try and quantify the amount of blood that you started with in the evidence.
I believe I answered this question yesterday, and I'll give the same answer. I looked at the stain. It was consistent with blood undiluted. I cut out the stain, and then I extracted with water. I looked at the water extracts. They had similar colors, and I also did a presumptive test, phenolphthalein, which gave similar responses.
You didn't use any analytical tests that are designed to determine quantity other than looking at it, did you?
I believe I just answered that question.
Okay. Now, you made an estimate of... Now, incidentally, have you ever tested your ability to measure quantities of blood by looking at it?
I think I did in this particular case. I mean, if you look at my controls that I ran on the samples, I got fairly similar results.
Have you ever done a blind study where you don't know how much blood is there and you're tested on your ability to recognize and quantify blood by just looking at it?
No.
Is there any textbook, any chemistry textbook that you have ever looked at or seen that recommends as a valid way of quantifying something for analytical purposes to just look at it?
Oh, I don't know specifically if there is or not, no.
Now, one of the calculations that you made here had to do with what's the biggest swatch we need to detect EDTA blood. Let's assume EDTA blood's on it, and what's the biggest swatch we need to detect it, right?
That's correct.
And it'd be very unfair if you ran a sample of the evidence stains that was around or smaller than what you knew to be the minimum detectable amount, right?
Yes.
Now, I'd like to use the chart, the paper chart back there. Agent March, you can step down if you like. Is this ready to see?
The problem is juror number 7, I don't think can see that because of the angle. And 165 may not be able to see it because of the height. You can see it? All right, thank you, sir. Mr. Blazer.
Now, Agent March, you determined the minimum size of a swatch that you needed to use to detect blood with EDTA in it as 1 square millimeter, correct?
That's based on negative ion results.
Okay. And tell us how you arrived at that calculation.
I took cuttings of different sizes of swatches, and I was able to draw a graph and calculate that would be the minimum size needed.
Well, you made us, you put 10 microliters of blood on some cloth material, did you not?
Yes,
And you measured the diameter, I'm sorry, the radius, or the diameter of that, did you not?
that's correct.
And could you draw, not to scale obviously, a circle that represents the 10 microliters of blood that you
Okay.
did to determine your minimum detectable amount?
Right.
And that's 10 microliters of blood. You want to write 10 microliters of blood?
I think it was probably 5, wasn't it? Is what I used.
Well, you want to look at your notes?
Well, I think for cutting this out, I did 5 microliters.
Well, I want you to be accurate. Look at your notes. 5 microliters. And you found that 5 microliters of blood gave you a spot that was how big?
Well, I had pictures of it. I can't remember.
You want to look at your notes?
Is it in there?
What was the diameter?
I think juror number 7 needs sanctions for causing so
fine.
many problems during
You
this
want to draw a
trial.
line that represents the diameter and write 5 millimeters. Okay, now below that, I want you to draw a little square that represents a swatch. Way below it. There you go. Thank you. And, well, we wanted a square one. You determined that you needed a square 1 millimeter on each side, right?
Okay.
Now, and you had previously determined by other tests that you needed not only a swatch 1 millimeter on a side, but 0.5 microliters of blood is the minimum detectable blood, correct?
Based on negative ion. On positive ion, it would be 1/10 of that.
Now put a 0.5 microliters down by the swatch. So is it accurate that you calculated that you needed a swatch 1/2 the size, I'm sorry, 1/10 of the size of your 5 microliter circle to get a big enough
Okay.
swatch to have a minimum detectable amount of EDTA?
Based on negative ion.
It's not as good as the glove. It's just nothing will ever be as good as the glove. So we need to set our bar lower, but it's still good. This is a dog.
Oh, okay, but that's the ratio we're talking about, correct?
No, we were talking about positive ion there. It
No,
would
no.
be 1/10.
Now in terms of 5 microliters, 0.5, there's a 10-fold difference.
Right.
So the area of your circle should be 10 times bigger than your swatch, right?
Right.
Can you calculate the area of a circle with a 5 millimeter diameter?
I mean, I could. I don't. Math. I don't know right now what it is.
Well, what's
Another
the
formula.
formula for the area of a circle?
Is it pi r squared?
And what's pi?
Well, you really tested me. 2.12? 2.17? I don't know.
How about 3.1214?
Is that what?
Isn't pi kind of essential to being a scientist, knowing what it is?
I haven't used pi since I was in, I guess, high school. I don't know.
Let's try 3.14.
Is that what it is? 3.
Yo, I'm gonna make a pecan pie this week. Well, it's Friday,
Try
but
3.14.
within the
What's
next
radius?
7 days.
So it'd be half the diameter.
Okay, 2.5. Squared, right?
Right.
You want to, may we borrow a calculator? Can you use a calculator?
Yes. I think.
Tell me what pi times 2.5 squared is.
Wait, no, calculator's on your phone, dude. Just pick up your phone, dude. Remember your math teacher said you had to learn math because you can't carry a calculator with you wherever you go?
19? I'll write down 19.
Liar.
Square millimeters, right? The area. What's 1/10 of that?
That glove drawing was so good.
You
Oh my
miscalculated
god.
by a factor of 2. The minimum size of a swatch you needed to detect EDTA, didn't you?
I don't know that I did or not. I calculated a little differently. I didn't use this.
Well, does the area change by the different methods of calculation?
Well, this is all estimations based on my eyeball. I didn't use any scientific math to determine it. What I did was I took the circle and I divided it in half. And then I divided it in half
Scientific
again,
math.
40. And I just
I
cut out
know,
pieces.
that calculator's
That's how I
so
did it.
big. Bobby,
So when you say in your report that you determined that you need
that's what you could do on your date. Pull out a calculator that big. And you'll hear her say exactly what Nan just said. Wow, look how big your calculator is.
a square 1 millimeter,
I said approximately. This is all approximate.
would you agree that under the conditions that you set forth in your report, that 1/10 of a circle of 5 microliters of blood is a swatch 2 square millimeters, not 1?
Approximately right. As I mentioned before, though, in the positive ion mode, it really doesn't make any difference because it will be 1/10 that.
Were you trying to be careful in the quantifications that you used?
I told you what I did, and I took small portions of it.
Of course, he's not
And use
being
that to
careful.
calculate.
We willy-nilly our quantifications daily. That's how we roll around here.
How much my minimum detectable limit was.
We take this down. Did you just say that you did this in a way that wasn't very scientific?
Well, I don't know if your definition of scientific is, but I took a circle and divided it in pieces and cut a piece out.
Not very scientific, is it?
Well, in this particular case, we got to go back to the original focus. Can we distinguish between preserved and non-preserved blood? We're talking 1,000-fold difference. Any imprecision that I may have had here will not affect my results.
Could we have chart B? This is, remember the number. 1271B, you remember that chart, Agent
Yes,
Martz?
yes.
Does that look like a 1,000-fold difference? These are your measurements, aren't they?
Well, you've got to remember with a mass
Agent move it straight.
No, he can answer the question. Ask
That-
him the question.
Does that appear to be a 1,000-fold difference to you from your own data?
in that particular thing,
Yeah.
no.
Now, Agent Martz, I'd like to ask you some questions about your ability to determine quantities of blood by looking at, okay?
Okay.
You provided me with some pictures of different spots of blood, did you not?
Yes, I did.
Sidebar with court please.
$50, $100, $110, $130. Those stupid freaking calculators. They were so expensive. They should have just told us all to get our kids a computer. You know, one of those big things you can carry around with you. Might have been cheaper. Oh, those calculators, man. Nan, I used to get so mad because I had 3 freaking kids. Which I know a lot of people have 5 kids or 8 kids, but jeez.
Agent Martz, did you do any testing to see what size
I'm
blood
making
draw
a
you would get from
pecan
various
pie
quantities of
this
blood?
week.
Uh,
Ay, ay, ay.
I did
Do
put
it.
a couple different size
Hell
drops
yes,
on
do it.
paper to see how big they were, yes.
And one of your methods that you used to estimate how much blood you had from the evidence was to look at those blood drops, correct?
No, I used that, basically put them on paper so I would know how much sample to take, and I measured a certain amount out, so I knew how large the area was.
Does the same amount of blood put on different substrates look different in terms of the quantity and size of the drops?
Yes.
How much different?
Oh, it would depend, maybe 20, 30%. I don't know specifically. I certainly didn't do any calculations.
You didn't do any testing of that at all, did you?
No.
Did you prepare some samples with blood drops to compare? Okay, you indicated you did one set of blood drops on different substrates.
I believe I did something on filter paper and one on a cloth. I think it was a towel.
Okay. Did you do a second sample of blood drops on the same kind of material as the towel?
I don't understand.
Your dilution experiment. Remember that? That you talked to me about?
I don't think I did that dilution experiment.
What was the material used for that dilution experiment?
I didn't do that experiment.
So the size of a blood drop, or your testimony is, it can only vary by 20%?
No, I'm not saying that. I don't know. I didn't measure. I gave you an approximation.
So you don't know how much the size of a blood drop will change given different substrates?
No, and that's why, in this particular case, when I did the sock, I made sure I used the sock as a control. And the gate was swabbed with the cotton swab, or cotton swatch, so I used the cotton swatch. I used similar material.
You didn't use, how do you know you used the same kind of swatch? You didn't look at them, did you?
Well, they were the type that are used for serology and DNA, and I got mine from the DNA unit.
In your opinion, can the size of a blood drop with a given quantity of blood vary by 8 times, depending on the substrate?
I've never observed that, is all I can say.
Your Honor?
Proceed. He indicated you didn't do that dilution.
Did you examine the photographs that you provided to me of blood spots?
I looked at them.
Did you examine the sizes of blood spots that you had in your photographs to determine whether or not, what the difference might be with different substrates with the same amount of blood?
We're back to the ones that I prepared?
Yeah, did you ever compare those to the dilution ones that were prepared for you?
No.
I'd like to refresh his memory with these.
He said he's provided them. I assume he's seen them. It's for the purpose of refreshing recollection. It's also a speaking objection. Have a seat.
Agent March, I'd like you to review those photographs.
I'd like to make a correction. This is something I did prepare here. I thought you were referring to the other one.
So you prepared both of those photographs?
Yes, I did.
You prepared the stains that are contained in the photographs?
Yes.
Now, may I have them marked?
Yes.
Two photographs.
1274 and 5.
1274 and 5?
Yes.
Agent Marks, when you prepared these, did you measure out the quantities of blood that you put on them?
Can I see those again?
Sure.
I know that I did in this one, and I can't.
Which one is that?
Oh.
What's the number?
1274, those are all labeled 5 microliters, so I know that that's what I did. In this other one, 1275, I don't remember what I did.
Do you remember me showing you that picture about an hour and a half ago and asking you how much blood you used for that second picture?
Yes.
You told me 10 microliters, didn't you?
I can't remember if that's what I said. I probably said 5 I don't know if I said 10, 5. I don't know what it is.
Did you tell me 10?
I can't remember. I can't remember.
Here, I'd like to show these.
1274 you can show. 1275 the objection sustained.
Let me ask you a foundational question. 1275, the second picture, was that the same substrate as the first?
I can't remember.
When you did the experiment, this dilution experiment, did you write down any of the conditions of your experiment?
No, I did not.
Is that because you could
That's right, another video under our belts. Yes, notch the headboard on your bed, ladies.
Agent Marks, looking at 1274, those are 5 microliter blood drops that you put on some sort of substrate, 2 different substrates, correct?
That's correct.
What was the substrate on the top ones?
I believe it was a towel.
And this was what you used to determine what a 5 microliter blood drop, or 5 microliters of blood would look like?
Yes.
Is that towel anything similar at all to swatches that you got with evidence?
In what respect?
In any respect.
Well, I don't know because I didn't do the test.
So you have no idea what 5 microliters of blood would look like on a swatch from LAPD, do you?
No.
And you are using quantities of blood in this experiment from the evidence that were relatively close to the minimum detectable amounts that you had determined for your negative ion test, correct?
For the negative ion, I was above the minimum detectable amount.
You were close, weren't you?
Oh, I don't believe I was that close.
Stain Q207 from the sock. You remember that one?
Yeah.
That was taken from the middle part of the stain rather than the edge?
The 207, I don't know. As I told you, I don't know where it came from. You showed me a picture. I don't know where it came from.
Did you ever ask?
I've asked many times, and I don't think I've gotten a satisfactory answer.
Is there more blood on Q207 than Q206?
Are you talking the total amount that's on 206 versus 207?
Yeah.
Or where I cut?
No, you're cutting. You're Q206 cutting.
I tried to take the same amount of cuttings from both. I tried to get the same amount of blood.
You didn't do a cutting on Q207, did you?
Yes.
On Q207.
Yeah, the first day, the charts are labeled 206, 207.
And did you have a lot of Q207 left over?
It's all relevant. Relative. I didn't use as much as was present. There's more present now than there was, or there's less present now than there was when I started.
So you didn't use all of Q207 to try and get as much blood as possible so that you could have higher amounts of blood to look for EDTA, did you?
As I mentioned earlier, in all the cases...
Move to strike, non-responsive.
Sustained. Re-ask the question.
You did not use all of Q207, which had much more blood than the cutting you took, correct?
I don't agree with that.
How much did you cut out of Q207?
In all cases, I took larger than the minimum amount that was needed, and I combined 206 and 207.
And you had determined the minimum amount you needed from your calculations of sizes of blood drops and what size square swatch you would need to have minimum amounts of blood, correct?
Yes.
Did you suspect when you saw the 160 ion in the back gate and the sock that there might be EDTA there?
Yeah, yes.
You could have used more blood than you used in that experiment to try and find the 132 daughter ion, couldn't you?
I didn't believe that it was relevant.
You could have used more blood, couldn't you, if you wanted to use a larger quantity of blood to try and find whether there was a true EDTA spectrum there, couldn't you?
To me, it was irrelevant, and I didn't want to consume all the evidence in case the defense wanted to use it.
You said you called the prosecution to see if you could get some more, didn't you?
Right.
That was for their test, right?
Yes. And I wanted to save some for the defense.
Did they ever tell you that you had a limitation on what you could use?
No, but I generally will never consume all the evidence.
Did you ever ask for some more so that you could run a larger quantity of blood to really determine whether there's EDTA there or not?
I didn't feel it was relevant.
Is the answer to that no? You didn't?
I didn't. What's the question?
You didn't make any effort to try and run more blood than you had run in your first set of tests to try and actually identify EDTA in the back gate and the sock, did you?
Well, I did, and that's why I went to the positive ion mode the next day, because I felt that EDTA may be present in blood.
Move to strike, non-responsive. Quantity, Agent Marks. Did
Please.
you ever try to test more blood that you had available to you when you suspected there was EDTA on the gate and the sock?
I felt there was a better way, and that was to do the positive ion, and that's the way I looked for the EDTA. It was 10 times more
I'll
sensitive.
be right
Did
back.
you ever consider using more blood?
Be nice.
No,
Be good.
I
You don't
always
really
try
have
to
be
save
nice or be
evidence in
good.
case the defense wants to examine it.
You had the sock at one point, didn't you?
Yes.
How large a cutting did you take compared to what was left on the sock?
I probably took no more than one tenth would be just an estimate.
You had plenty more sample on the sock, didn't you?
Yeah.
You weren't concerned with using up what you had available on the sock, were you?
I didn't know what other testing needed to be done. If DNA testing needed to be done, there would be more blood needed. Now, if it was just for EDTA, it'd be another question. There's more things that can be done with a blood stain than EDTA.
Did you ever ask, can I take another cutting because maybe I better use a little bit more blood since we're pretty close to minimum detectable limits?
No, because you weren't concerned with that, because minimum detectable limit had nothing to do with whether or not it was preserved or non-preserved blood. In preserved blood, there was so much present, it didn't make any difference.
If you test around minimum detectable limits, you're going to find less, aren't you, if it's there? A lot less, aren't you?
Well, I don't know about a lot less. Every instrument has a minimum detectable limit, and you either have it or you don't have it. In the sock and the gate, I didn't have it.
Did you ever consider trying to test your suspicion that you found EDTA by testing a larger quantity of blood?
In this case?
Yes.
No.
No further questions.
Ms. Clark.
Mr. Marth, why would it not be relevant to use more blood to determine whether or not you had EDTA from preserved blood?
As I mentioned earlier, it was actually a very easy analysis. It may seem complicated, but it was actually very easy. The stains were taken from approximately the same amount. I always made sure that I took more stain from the question sample than I did the known. And as you saw from my charts, it's very easy to differentiate between blood that's preserved with EDTA and blood that's not preserved.
And by taking more stain from the evidence, would you encourage higher readings from the evidence than you would ordinarily if you just took even amounts from the evidence and the reference sample?
That's correct.
And in that way, you overcompensate for any variation in size by making sure that the evidence reading is going to be overrepresented.
That was my theory, and that's why I did that, yes.
So if anything, the readings that you got in the evidence graphs and chart results that you have overrepresent the amount of EDTA.
That's correct.
Now, you talked about detection limits, sir.
Your Honor.
We lost our operating line.
Well, try it the old-fashioned way.
That's okay.
You may. Proceed.
I'll go to something else in a moment. So you talked about detection limit. Let me ask you this. Whatever size of blood stain you take, be it 5 microliters, 10 microliters, whatever. Assume it's 5 microliters. That's very small, isn't it?
Right.
When you test 5 microliters of blood, if it is 5 microliters of blood that comes from a tube containing EDTA preserved blood, will you detect EDTA?
Yes, it's very easy to detect EDTA in a stain. With a positive ion mode, it would even be 1/10 the size of a 1 millimeter square, so it would be extremely small size.
And if you run that same sample size, as small as it can be, and it is unpreserved blood, will you detect EDTA?
In unpreserved blood,
Right.
I've not been able to identify EDTA from blood stains that size.
Then what does that tell you about the detectable limit? If your signal is so weak, sir, that it is below the detectable limit in your blood stain, does that tell you that EDTA has not been identified?
That's correct.
In that respect, sir, is it irrelevant whether or not you use more blood or less blood?
As long as I use the same size stains, it's irrelevant.
Because even if you use very little blood, EDTA will produce a strong signal if it is present.
That's correct.
And by that I mean EDTA preserved blood.
Yes.
Now, Mr. Blazer asked you whether or not you've ever called defense attorneys to advise them of what you tell the prosecutors about when you work on cases for prosecutorial agencies. You recall that?
Yes.
Have you ever refused to speak to a defense attorney who had questions of you?
No. No.
Have you ever refused to speak to Mr. Blazer when he had questions of you, sir?
No.
And has he had questions of you, sir, throughout these proceedings?
Yes, he has.
And have you answered them?
Yes, I have.
In fact, have you approached him to ask him if he had any questions?
Yes.
And did he have some?
On several occasions, yes.
Did you answer them?
Yes.
You indicated, sir, that you were confused by the fact that he wanted to call you as a witness.
Yes.
Why is that?
Because my results clearly show that EDTA is not present in the bloodstains in question.
Now, sir, as to all of the evidence testing, now with that in mind, I mean the evidence of the blood on the gate, the blood on the sock, did you write reports containing your conclusions and your results and the testing procedures you followed to be provided to the prosecution and the defense?
Yes.
And when did you provide those reports?
It was probably the end of February, the beginning of March. I don't have the exact date.
Okay. And those reports indicated your conclusion that no EDTA from preserved blood was present in the evidence.
That's correct.
And having provided them by the end of March, sir, if you wanted to prove that EDTA blood, preserved blood, was present on the evidence stains, what tests would you conduct?
Well, I would conduct the test that I performed here.
To your knowledge, has the defense conducted such tests?
I have no knowledge of them conducting those tests, no.
If you wanted to prove that EDTA preserved blood, when you have EDTA preserved blood, that the EDTA will break down or degrade when subjected to sunlight, high-intensity light, rust, fertilizer, or metal, or environmental conditions, would you conduct experiments under those conditions to prove that hypothesis?
Yes.
To your knowledge, has that ever been done by any defense expert?
Not to my knowledge.
In your opinion, sir, between the beginning of March when you turned over your results and now, would there have been ample time to conduct those experiments?
I believe there would have been, yes.
Would there have been ample time, sir, to conduct any tests
Objection.
on the evidence?
New approach.
Yes, with the court order, please. Thank you, counsel. Proceed.
Sir, had a scientist with the equipment of the liquid chromatograph tandem mass spectrometer, if such a person had that equipment, could they, between the beginning of March when you provided your results to the defense and now, have conducted tests on the socks and on the gate to determine the presence of EDTA preserved blood?
Yes, they could.
And in that space of time, sir, could they also have conducted tests involving the use of an internal standard, like the one pointed out to you by counsel from Cambridge, to quantify the amount of blood being tested in the evidence as well as the reference samples?
They could have quantitated the amount of EDTA. To quantitate the blood, they would have to use a different procedure.
But they could have adopted a procedure to quantitate the blood,
Yes.
and they could have then tested that blood,
Yes.
and they could have then quantitated the EDTA present in the evidence and in the reference blood.
Yes, they could have.
This is Defense 1274, sir. Can you tell us what was the point of this?
Well, when I made the 5 microliter blood sample, I was able to cut it in pieces and determine my minimum detectable amount of blood stain.
And what were you attempting to show here?
Well, I needed a certain amount of blood in order to determine the minimum detectable amount. So I placed a known amount of blood and took a portion of that and tested it.
Okay. Were you trying to visualize what that amount of blood would look like?
No.
That was just blood stains showing that was the amount that you were testing,
Yes, that's
not
correct.
what it would look like.
No.
All right, you were shown. I'm going to show you what it's. You were shown People's 544E, and you I've informally labeled these. I'm going to ask you the court to label them with handwriting or typing that's better than mine. Okay, these show the graphs of the evidence blood stain on the gate.
Yes,
And in this chart, you indicated that the 160 was not shown in the full daughter spectrum.
that's correct.
Although you indicated, detected it, you thought, in the scan where you were only looking at the daughter 160 on the gate evidence, correct?
Yes, that's correct.
What does this signify to you, that when you ran the full daughter spectrum to try and achieve 293, 160, and 132 at the same time, you could not do so?
It indicated to me that I could not identify EDTA because I needed those ions to identify EDTA.
And you hypothesized with Mr. Blazer that the 160 was below your detectable limit?
That's correct.
Well, if it's below your detectable limit, sir, then can it be EDTA from preserved blood?
No, it cannot.
And is that because the signal given, no matter how small the amount of blood, the signal given for EDTA preserved blood is so strong that you should get the full daughter spectrum whenever you run it?
That's correct.
And so you did not.
And I did not in this case.
You were shown this chart, sir, by Mr. Blazer.
Yes, I was.
Does that chart reflect any testing that you ever conducted?
No, it does not.
Does that chart reflect any result that you ever obtained in any test?
No, it does not.
Does that chart have anything to do with the work that you have done and actually obtained the results in this case?
No, it does not.
Does that chart reflect the results of the testing of any of the evidence in this case?
No, it does not.
Or any of the reference samples in this case?
No, it does not.
Is that an accurate depiction of your testimony as it relates to the comparison between the amount of EDTA found in preserved blood versus the amount of whatever substance that is in the evidence stains?
Could you repeat that, please?
No.
I didn't think you could.
I'm not even going to try and read it. Does this chart, sir, accurately reflect your testimony concerning the discrepancy, the dramatic difference between the EDTA signal you got from the reference samples, that means blood from preserved EDTA tubes, and the evidence stains in this case?
This chart does not reflect any of the testing that I did whatsoever.
Does it accurately reflect any of your testimony, in your opinion, concerning the dramatic difference between the signals you got in the reference samples and the evidence stains?
No, it does not.
All right, Ms. Clark, you've been referring to...
That was Defense 1270. Thank you. Now, you recall being shown a square from the sock. There was a chart done by the defense. Sir, you remember this diagram?
Yes, I do.
It indicates that 207 was taken from the lower right-hand corner as you face this diagram.
Yes.
Do you have any idea whether that is true or not?
No, I don't know where 207 came from.
When you received 207, was it a cutting in a tube?
Yes, it was.
And then you took a cutting from that?
Yes,
Now, you indicated that you, in fact, did test 207 and 206 on the first day.
that's correct.
Did you take a cutting from the small cutting you found in the tube marked 207?
Yes,
And the cutting 206 is the one you made from the sock itself?
that's correct.
You do not know, then, whether 207 actually came from the area right next to 206.
No, it's my understanding it just came from somewhere in that blue area, or blue-green area.
Now, when you did the combined testing of 206 and 207, was that in the negative ion mode?
Yes, it was.
And your result was?
No EDTA was identified in that particular stain, and that stain did not come from preserved blood.
Now, sir, you indicated... I'm going to show you the two charts that have been previously marked as people's 543 and 544F, respectively. These are labeled, this is the gate with EDTA blood applied. This is where you put known EDTA blood on the gate swatch. If the blood recovered from the gate, the evidence blood in this case, were actually blood from the tube with preservative EDTA in it, is this the signal you would expect to get?
Yes, it is.
And when you tested the actual blood recovered from the gate, the evidence blood, is that the signal you got?
No, I did not.
And look at the chart now up.
That's
And
the
that-
signal I got, yes.
And that is the signal you got that's on people's 544E.
Yes, that's correct.
And if the blood on the sock had in fact been blood from an EDTA preserved tube, would you have expected to get the signal shown in people's 543F?
Yes, I would have.
And is that the result that you got?
No, it is not.
Showing you people's 543E. This is your graph of the evidence blood tested for EDTA on the sock. This is the actual evidence. Is that the result that you got?
Yes, it is.
And in each case, with respect to the blood recovered from the sock and the blood recovered from the gate, did your test results consistently show from May 19th through May 22nd, or 23rd,
28th.
28th, that there was no EDTA preserved blood in the stain on the gate and the stain on the sock?
In all the tests that I performed, no EDTA was identified in the stain from the gate or the stain from the sock. Those stains did not come from EDTA preserved blood.
Do you have any doubt about that, sir?
I have no doubt whatsoever.
I have nothing further.
Mark, would you agree that your ability to quantify any of these amounts relies upon your ability to accurately calculate or estimate or look at and determine how much evidence you started with?
Not to distinguish between preserved and non-preserved blood, I don't agree with that, no.
You don't think the amount of evidence that you started with when you tested has anything to do with your ability to detect EDTA?
I don't believe, with the precautions I took, that it would have any effect whatsoever.
Now, would you allow us how an expert with a great deal more experience than you might differ with your opinion?
What was the question?
Will you allow us how an expert with a great deal more experience with you might differ from your opinion?
Experience in what?
EDTA, mass spec, degrees in chemistry, toxicology, pharmacology?
I don't think anyone probably in the world has more experience with identifying EDTA in forensic samples than I do.
No further questions.
All right, let me see counsel without the court reporter, please. All right, ladies and gentlemen, we're going to take our recess for the evening at this time. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. As far as the jury is concerned, we'll stay in recess until 9 a.m. tomorrow morning. All right, Agent March, you may... And Mr. Goldberg. All right, counsel, we have a number of legal issues to discuss before we start with the jury. I have the jury upstairs in the lounge, since we'll probably be at this for a while. What I have scheduled is the first morning session to approximately 10:30 for motions this morning, but we have a number of matters we need to take up. Counsel, what's your pleasure as far as which motions to address first? Ms. Lewis?
Your Honor, I think one of the first things maybe scheduled for today was a hearing with regard to collateral impeachment witnesses of Detective Furman. May we go ahead and handle that one?
All right. Good morning, counsel.
Good morning. Your Honor, this is a motion which was brought because of the defense desire to use additional extrinsic evidence to collaterally impeach Detective Furman's credibility. As the court is well aware, you have wide discretion in the use of extrinsic evidence for collateral impeachment and in collateral impeachment as a whole. And it's an area where many courts do exercise their discretion in precluding substantial evidence of collateral impeachment, because it does tend, no matter what the issue and what the trial, to take things off of track in terms of the probative evidence in the case. Now, in this case, early on, the court heard the offers of proof from the defense with regard to a variety of potential witnesses with regard to Detective Mark Furman. And the court ruled, if I recall, that because Kathleen Bell had indicated that the racial statement she attributes to Detective Furman talked about a black and white couple together, and also implied the manufacture of evidence, that the court felt because...
No, it directly implicated the manufacturing of probable cause.
All right, exactly. And I believe that's what the court felt was most probative about that particular offer of proof from the defense, if I'm not mistaken. So that's why the court used its discretion in terms of allowing the defense to use that collateral impeachment, extrinsic evidence of collateral impeachment. And later, after that, the defense came up with Andrea Terry, who corroborates in some ways, though she actually contrasts with Kathleen Bell on an important point. But from the defense way of thinking, apparently she corroborates Kathleen Bell, and she as well indicates or alleges that the detective used a racial slur with regard to black and white couples being together. So for the combination reason that she indicated black and white couples and that she tended to corroborate in the defense eyes, at least Kathleen Bell, the court allowed cross-examination with regard to her statement as well. Now, in this case, early on when the court made those rulings, the defense had impliedly, if not openly, asserted over and over and over that they would be producing evidence that Detective Furman had either the opportunity to plant the Rockingham glove or actual evidence that he did so. And now here we are through the people's case, most of the way I understand, through the defense case, and they still have no substantial evidence of any police conspiracy. They have no evidence whatsoever that Mark Furman had any opportunity to plant evidence, that he actually did plant any evidence, and I'm sure the court appreciates the distinction when you look at the Hall type of cases, but I'm not even drawing that analogy today, Your Honor, with regard to Hall. I'm asking the court to look purely at the probative value of extrinsic evidence to impeach Detective Furman, given the lack of any evidence in this case linking him to actually doing anything wrong. That makes the probative value of him being a racist almost nil, because even if the defense were to successfully convince the court or anyone else that Detective Furman made these racial slurs and is a racist, that does not show any kind of a link to him actually have planting the Rockingham glove. So this wish on the defense part has just not come true. They have not been able to come up with any evidence that links them to that. Consequently, the evidence showing that he's a racist does nothing in terms of proving their case. On the other hand, because of the inflammatory nature of the remarks at issue, especially in front of this predominantly African-American jury, it does have a substantially undue prejudicial impact on the people. It is something that is abhorrent to hear, and the jury is going to be hearing it already in the form of Kathleen Bell and another racist statement in the form of Andrea Terry's testimony. So the court has, I believe, generously allowed the defense, and based on good reasons that Your Honor indicated, but has generously allowed the defense the use of these two witnesses that go to this collateral impeachment issue. That is, when you consider the detective's credibility, it's just not as important as it may have once appeared. We have not only the discovery of the glove at Rockingham, but other overwhelming evidence of guilt in this case. The DNA evidence at Bundy, the size and make of the footprints, the shoe prints rather, left at the Bundy scene, the trace and fiber evidence, the lie to Alan Park that the defendant said that he was sleeping when Alan Park had just seen him enter the residence. There is a lot of evidence in this case. This case does not hinge for one moment on the credibility of Detective Furman.
But do you think the defendant owes an explanation to a limousine driver where he's been?
I don't know if he does or not, Your Honor, but the point being he didn't have to say anything. If that were the case, if he owed no explanation, he didn't have to say anything. He certainly didn't have to say, I've been sleeping. The point is that he did say that and that it was a lie. So why did he make a point of making a lie to a limousine driver when you're right, he didn't owe him any explanation whatsoever. He simply volunteered that lie. And I would say as an alibi of sorts, though it changed over time. And as the trial got going through opening statement into chipping at golf clubs and so forth. Now, in addition, Your Honor, with regard to these recently acquired witnesses from the defense, this court has heard numerous motions for months, precipitated by the defense Pitchess motion last fall, about alleged racial slurs attributed to Detective Furman. All of that has been broadcast repeatedly to the media. Detective Furman's potential or alleged racial animosity has been an issue before the whole public for many, many months. And in addition, when Mr. Bailey cross-examined Detective Furman, that again brought it to the forefront of this trial. So for the defense to now have recently acquired witnesses, recently discovered witnesses, renders their credibility highly suspect, these people who apparently have only recently come forward. In addition, to the best of my knowledge, and perhaps we can be enlightened since the discovery on these witnesses is very rough and inadequate to really know what time period they're talking about, it's my understanding from other sources that these witnesses alleged overhear of statements by Detective Furman went back to the mid-1980s, possibly 87, 88. Perhaps the court can ask for a detailed offer of proof in that regard. But the remoteness of those statements, in addition to there being additional witnesses for collateral impeachment, on the detective's credibility, when his credibility is really not that important now at this stage of the trial, all of that militates in favor of the court exercising the wide discretion that it has and excluding those witnesses. And, Your Honor, since I want to save a little bit of time in rebuttal, I think I will submit with that for this part of the argument.
Mr. Ullman. Good morning, sir.
I think much of the argument with respect to this motion really misses the point. The defense is less interested in proving that Detective Furman is a racist than we are in proving that Detective Furman is a liar. When the glorious moment finally comes when Your Honor instructs the jury and sends them out to deliberate, I'm confident that one of the instructions you will give, and the reason I'm confident is because both sides will be requesting this instruction. The prosecution already has, and we certainly will.
I just smile at your thought that might be a glorious moment.
The instruction I'm referring to is CalJIC 2.21.2, which will tell the jury that a witness who is willfully false in one material part of his testimony is to be distrusted in others. You may reject the whole testimony of a witness who willfully has testified falsely as to a material point, unless from all of the evidence you believe the probability of truth favors his testimony in other particulars. Now, Your Honor can certainly anticipate that we will argue that instruction with respect to the testimony of Detective Furman, because in that testimony, number one, he flatly denied the Kathleen Bell incident and set up really a test of whether we're going to believe his testimony or believe the testimony of Kathleen Bell. And then he went on in the examination by Mr. Bailey to testify as follows. And you say under oath that you have not addressed any black person as a nigger or spoken about black people as niggers in the past 10 years, Detective Furman? Furman, that's what I'm saying, sir. Question, so that anyone who comes to this court and quotes you as using that word in dealing with African Americans would be a liar, would they not, Detective Furman? Answer, yes, they would. Question, all of them correct? Answer, all of them. Now, this testimony, quite simply, dug a hole for the prosecution, a very deep hole. And over that hole is a headstone that reads, falsus in unum, falsus in omnibus. And that's precisely what CalJIC 2.21.2 is going to tell the jury. Now, we proposed to present not only the testimony of Kathleen Bell and Andrea Terry to establish that the conversation alluded to about interracial couples did take place, but we will also present the testimony of Carol Hannock and Natalie Singer. Ms. Hannock, the evidence will show, dated Detective Furman's partner, Tom Vetrano, in 1987, practically contemporaneous with the Kathleen Bell incident. She lived in an apartment in West L.A., and on several occasions, when Mr. Vetrano came to that apartment to pick up Ms. Hannock, he was accompanied by Detective Furman. And in conversations that took place at that time, Mr. Furman frequently used racial epithets, including the word nigger, and expressed great racial animosity in the presence of Ms. Hannock and also in the presence of Ms. Hannock's roommate, Natalie Singer, who will testify that she was present on these occasions, that she heard these epithets, and that she was so offended by them that finally she refused to let Mr. Furman come into the apartment anymore. And finally, we will not be calling Maximo Cardoba at this time, but we do propose to call Roderick Hodge, a gentleman who was arrested by Detective Furman on several occasions in the period 1986 to 1987, again contemporaneous with the Kathleen Bell incident. He will testify that his father is African American, his mother is Caucasian, that this fact was apparently known to Detective Furman, that Detective Furman had arrested him on several occasions, and on one of these occasions, in January of 1987, after arresting Mr. Hodge for a drug offense, he turned to him in the back seat of a police cruiser and said, "I told you we'd get you, nigger." And then in a subsequent strip search of Mr. Hodge and several other African Americans who were arrested with him, he had them bend over in the course of a strip search and said, "You guys look all alike to me." Now, the significance of this evidence is not simply that it shows that Detective Furman is a racist. This evidence shows that Detective Furman is a liar. And the importance of these witnesses is that they all corroborate each other. We haven't heard any concession from the prosecution that they are ready to concede the credibility of any of these witnesses. I think we can anticipate that these witnesses will be attacked. In fact, they already have.
YouTube told me it was August. No, YouTube told me it was September that we had to worry about these comments. And I went back to August and I looked and they were in August. So I thought I needed to start at August. Nowhere in YouTube does it say that in July I needed to worry about this. Nowhere. Nowhere. Absolutely nowhere. Okay, here's what I'm going to do. There is a link in the description to this playlist. We are on video 374. You can watch it yourself if you want to hear more about what these people are saying. But I'm going to listen to Ito. I'm going to go to Ito. I'm bumping it ahead to Ito, and we don't need to hear that. We don't. It doesn't make a difference in our days.
One precedes the other. I think what we determined from the Newsleak issue then determines the broadness of the inquiry regarding Michelle Kessler. In our informal discussions yesterday, at sidebar at the conclusion of the day and discussing the matter with counsel, Michelle Kessler as the then...
You know, when I decided to play the O.J. Simpson trial, I had literally no idea this was an issue. I thought it was a murder trial about two people who were murdered. I didn't find out until after we started playing it that there was going to be this part of it. I had none. I don't know if I was asleep back then or what, but I didn't watch the O.J. trial back then. But I had no idea that all this racism, I mean, I knew in general there was a race issue, but I just thought it was because a black man stabbed a white woman, and back then, you know what I mean. I had no idea. Yeah, I did. As soon as she started talking, I knew I was in big trouble, and maybe I might have stepped on the gas a bit. Maybe. Sorry, someone was outside, and everything's burning down right now. So if there's someone outside, I have to check. So this cat you hear crying is perfectly fine. I swear, it's perfectly fine. It was wet and cold out last night, so I brought her into the warmth of my house, and she is very mad at me. Very, very angry at me. Nope. But don't worry, she's only angry because she's warm and safe and full. I fed her straight turkey last night, not even cat food. I hand-fed her turkey. She's fine.
Then acting head of the laboratory, now the head of the laboratory, can testify to several things that are relevant to this case: the procedures in the lab, who's responsible for what, how their documents are kept. She also conducted the inventory of the evidence that was conducted during the preliminary hearing, and she did in fact examine the socks during that inventory, and I think the defense wants to point out that she saw no readily apparent blood on the socks. So I mean, I can see that there are normal reasons why her testimony would be relevant in this case. The other issue, though, the information about news leaks broadens that inquiry significantly, so I think we need to explore that avenue first. And Mr. Goldberg, do you concede that she is subject to being called as a witness as to the standard issues?
Well, the phrase standard issues is fairly all-encompassing. And I believe that what the defense really wants to do, or might want to do, is follow that position, is call it the standard issues, and then impeach her. And I don't think that is proper. I'd like to address that at some more length when we actually get to the question of Michelle Kessler's testimony. But perhaps, as the court is suggesting, you could address the issue of the news leaks first.
I think the news leaks is really what determines the scope of what we're going to do.
Thank you. I'd like to start then, Your Honor, by discussing the lack of relevancy of the news leak issue. We did file a supplemental points and authorities on this. I don't know whether the court had an opportunity to read that. That was filed at 4:30.
I've got it.
And after talking about the issue of relevancy, which seems like it is a threshold issue, obviously, if the court were to get past that, and we're not suggesting the court ever will, then there is an issue as to the mechanics of how you would go about proving this through admissible evidence. And we have suggested in our points and authorities that that can't be done because there is no legally admissible evidence to prove what it is that the defense seeks to prove here. So starting out with the issue of relevancy, we'd first point out, as we did in our points and authorities, that speculative inferences that are derived from evidence cannot be deemed to be relevant to establish the speculatively inferred fact. And that was a quote that came from the case of People versus Babbitt. We suggest that this is a classic case where what it is that the defense is offering is not evidence, but merely a speculative inference that they will be asking the jury to draw from the question of the news leak. Now, in order to get to the speculative inference, that is that the evidence on the socks were planted from the news leak, there is a chain of illogic that the defense must go through. And I tried to break it down into three components that would logically be involved in that chain. The first chain is that the defense would logically have to show or prove either directly or circumstantially that there was in fact a news leak stating DNA results. And the reason why we say that this first part of this chain of logic has not been established or cannot be established is that what we have is a situation where on September the 18th, as the court will recall, Gregory Matheson did a PGM subtype test on the socks and found that the PGM subtype was consistent with the victim, Nicole Brown. As the court also knows, very often the serologists refer to these tests involving blood proteins as genetic markers. So we have a situation where there was a test that was being done for genetic markers that found blood that was consistent with the victims on the 18th. The so-called leak was on the 21st. So we don't know, for example, Your Honor, whether what we have is a situation where the news media received information and misinterpreted that information and reported this genetic marker test as being a DNA type test. We don't know specifically what, if anything, was said. And just to give a little bit of an illustration on that, Your Honor, there was an incident quite recently, I don't know whether the court is familiar with it, where some of the detectives in this case were talking and joking out on the courthouse steps with some of the T-shirt vendors, as they frequently do. And one of the newspaper reporters or television reporters, I won't name the agency, asked who these people were, and in what the detectives felt was an obviously joking manner, said that these were 4 surprise prosecution witnesses that we were going to put on at the tail end of our case. The news reporter promptly scurried off, and this was shortly thereafter reported in the media that we had these 4 surprise witnesses, and reporters were scurrying all over the building trying to find out who they were. This was a situation where on its face anyone should have known that that is not a reasonable possibility, that we have discovery laws, we have to disclose people, you don't suddenly just march 4 people into court and put on surprise witnesses. Clearly something that any reasonable person would have seen as being a offhanded comment, a joke. We have seen instances like this over and over and over again, where the news media has completely mischaracterized or outright misstated what happened in court or what happened outside of court. So I do not believe that there's any reason to conclude that they did not do so in this particular case. Also, as the court ruled at the time that this came up back in September, and these were Your Honor's words, let's not even dignify it as a news leak. It is a fabrication, end quote. Your Honor also found the conduct of the news media outrageous and irresponsible. So how are we supposed to infer, based upon the rulings that the court has already made?
And that comment was made in the context of pre-jury selection, and at a time where obviously the court has to be concerned with the defendant's right to select a jury and have a fair trial.
And Your Honor, I think also commented at that same exact time that this also might prejudice the people's right to a fair trial to the extent that it was releasing information that might not necessarily prove to be correct. But the point is, Your Honor, how are we supposed to conclude in a environment where all of us agree, the court, the prosecution, the defense, that stories have been repeatedly put out over the airwaves and in the print media that are incorrect and even irresponsible at times? How are we supposed to trust at face value this story as having accurately stated what was supposedly heard from the source, if indeed there was a source? And this is particularly a problem where we won't be able to cross-examine the person from the news media as to who the source was, what specifically they said, because there is a privilege that attaches. And we can't possibly, therefore, ever explore or undermine this kind of testimony. I don't even know how it could be presented in light of that privilege. The next speculative inference in this chain of illogic, Your Honor.
All right, well, let me ask you this, though. Don't we have to then
True,
first determine
Jenny. True.
by summoning in the person who...
If you drink alcohol, if you drink tonight at 6 p.m. your time, wherever that is, raise a beer for juror number 7 with me. Everybody drink a little bit of alcohol tonight at 7 p.m. 7 p.m., whatever that is your time, not 6. Let's move it to 7. All for juror number 7. We're going to be drinking.
originated this report in the...
Joke's on all of you. I'm going to be drinking for juror number 1, 2, 3, 4, 5, and the alternates.
the commercial news media and a demand from that person production of the source of that information. Don't we have to do that first? And perhaps in this situation that person will agree to divulge the source, and then if not, we'll have to conduct a contempt hearing.
Well, there's also a privilege, as the court is aware, that applies to protect unpublished information as well as sources. And we've already been told, I believe, it's already been represented to this court, that that privilege would be invoked here, which is another issue that we also addressed in the brief, Your Honor. But I do agree with the underlying premise of the court's question, which is that before this information could be put before the jury, we would have to have some evidence in an admissible form that the proponent of the evidence, the defense, could put forward to indicate that there was a source for this information, and specifically what the source said. But I go even one step further than the court has just suggested, and that is that in addition to that, they would also have to indicate that that source was an individual from SID in order to make the evidence probative on the issue of evidence planting. And if all they are going to say is that we have a source, that part of the relevancy inquiry is not addressed, because the source could have been, if we're looking at all of the potential candidates for suspicion, SID. It also could have been the police. It also conceivably could have been the Department of Justice. It could have been the DA's office, or it could have been the defense. All of those are possibilities. And there really isn't any evidence that points to any one of those 5 candidates more than the other, if all we have is information that there was a source. The defense said in their moving papers, well, the source said, or the news media said this was a source that was familiar with the investigation. But that does not exclude any one of those 5 candidates that I just mentioned. All of those 5 candidates would fall within the rubric of people who are familiar with the investigation. Or to add a 6th candidate on, Your Honor, it could be an eavesdropper or interloper who intercepted information from any one of those 5 sources. So it also could have been an unintentional disclosure. The third problem in this chain of logic that I've been addressing, Your Honor, on the issue of relevancy is that even if we could assume that there was a leak, and even if we could, in addition to that, assume that the leak came from SID, is that leak, that assumed leak, probative on the issue of evidence planting, the issue that it's being offered to prove? And I suggest that it is not very clearly. I'd point out, Your Honor, that if we knew that there was evidence on the socks, which we did on August the 4th, significantly before Greg Matheson's PGM subtype and before the news leak. We knew that through the presumptive testing that was performed on that date. There are 7 permutations of whose blood could be on the sock. It could be the blood of Nicole Brown and the defendant, Nicole Brown and Ronald Goldman, Nicole Brown Ronald Goldman, and the defendant, Ronald Goldman, or the defendant and Ronald Goldman. Those are the only 7 possibilities. So simply by guessing, once we know that there's blood on the socks, if we simply guess it's Nicole Brown's blood, we have 4 permutations that include that as one of the possibilities, or a 57% chance of being right.
Refresh my recollection as to what the news report said back in September.
The news report said that blood was found on the sock and that it was reported to be that of Nicole Brown. It didn't say...
By DNA typing.
But by DNA testing. Well, I think one report was that it was the victims, and I believe that there was a subsequent report saying it was Nicole Brown, as I recall. I just listened to it the other night. There were 2 reports. There was one on the 21st and one on the 22nd.
One on the 21st when the claim was made, and on the 22nd when it was reaffirmed.
Yeah.
All right.
But, well, they also said that it was, I'll get to that, they said it was PGM, and, excuse me, they said that it was RFLP and PCR testing. But the point is, Your Honor, is that just by guesswork, if the source said it's Nicole Brown's blood, they have a 57% chance of being correct.
I don't recollect that the 21st or the 22nd that Nicole Brown's name came up specifically.
I thought they had said that, but if they didn't say it and they said that it was the victim's blood, just generically, then there are
Do we have that
6
video?
out of 7. Then they have a 6 out of 7 chance of being right.
Do we have that videotape available?
Yes, I have it upstairs. But the point is, Your Honor, is if they simply said the victim's blood, which is I think what they said on the 21st, then I think there's a 6 out of 7% chance of being right. And probably greater, because it would be a reasonable inference that because there was a lot of victims' blood at the
Let me
scene.
look at it again, because whether they say have specifics as to whose blood is there, that's an important issue.
Yeah, but I would submit, Your Honor, that if they had said it's
No,
Nicole...
I understand the permutations. I
Yeah.
understand what the possibilities
Okay,
are.
but had they said it's Nicole Brown's blood and the defendant's blood, then at least the argument that there was someone, that this was someone with inside information would be slightly stronger than if they simply said it was the victim's blood.
Before we get too far away from this point, Mr. Douglas, do you have that available?
While we're waiting that, does the court want me to continue, or does the court
Let
want me to?
me just satisfy my curiosity and refresh my recollection as to what this said, because I think that has the specifics of what is said is important for the rest of the inquiry, I think.
Bloody socks. On an LAPD inventory list of the 234 items confiscated from the Simpson estate, the socks are number 13. The list reveals they were found in Simpson's bedroom. Sources say the men's socks, said to be O.J. Simpson's, which had several blood drops, were sent by prosecutors to Selmark Lab in Maryland for DNA testing. And now that testing is complete. Sources have confirmed results from RFLP testing, the most definitive type of DNA test, reveal that the blood on Simpson's socks is a genetic match with Nicole Brown Simpson's blood. The question, how did Nicole Brown Simpson's blood get there? That's a question that may be very difficult for O.J. Simpson to explain.
Thank you for rerunning that tape. I also see on the tape, though, that they, and I should have picked up on this earlier, that they said that the socks were sent to Selmark, and in fact they were sent to the Department of Justice. So that's another inaccuracy in the news report, which again leads us away from the conclusion that the person had inside information. Obviously, they said that it had already been sent for DNA testing, and that wasn't true because it wasn't sent out until the 26th of September, which was a number of days after the leak. So that's another misstatement. And then in the retraction story, this was after Ms. Clark was in court and said to the court, no, the items have, excuse me, she said, no, the socks have not yet been sent out for DNA testing. Following that statement in court, the news media reported, well, that's true, the socks haven't been sent out. However, a cutting from the sock was sent out, and that's also incorrect because we had neither sent out cuttings from the sock nor had we sent out the sock itself as of that date. So all around, the report that was issued by the news media is incorrect. The only thing that they state that can be characterized as being correct is that Nicole Brown's blood was on the sock. However, that's only a partially correct statement because the defendant's blood was on the socks as well. So there's nothing about the report itself which leads us to the conclusion that it came from someone with inside knowledge or someone other than a crackpot. And there is every indication in the report itself that it did not because of the numerous inaccuracies of the report. Now, getting to this third relevancy issue, and that is, I think, probably the key one here, is even if we could get over the other two relevancy hurdles, why would a leak be relevant on the issue of evidence planting? The defense has simply assumed that it would be relevant without articulating why it would be. And in trying to articulate that a little bit, I'd like the court to envision two scenarios. Under scenario number one, we'll call this evidence planting scenario number one. What happens is the socks themselves are planted at the defendant's home. But apparently, according to
I
the
don't know if
scenario,
they said.
when the socks were seen on the 24th of June and the 29th of June, there's no blood on them. This is the inference that they want the jury to believe. Therefore, someone planted blank socks. So under this evidence planting scenario, maybe what happened was the person that planted the blank socks was listening to the news media and heard this story about DNA testing and thought to themselves, oh my heavens, we planted the socks, but we forgot to plant blood on them. And then as a result of having been reminded by the news story that they had forgotten to plant blood on the socks, got dressed up in their ninja-style evidence planting outfit, and then put the blood on those socks.
All right, well, if you argue that the defense argument is speculative, let's get back onto terra firma.
Well, it's not just speculative, Your Honor, but I don't think that the defense can logically assert that theory, that the news report itself...
Let's agree nobody likes that theory.
Okay. So let's try theory number two then, evidence planting theory number two. And that is that, and it seems to be inconsistent, by the way, with evidence theory number one, which I think the defense in part has pursued, because they've suggested that blank socks were in effect planted. But let's take evidence theory number two, and let's suggest that what happened was the evidence was planted prior to the time that the news story came out. Then what happened under defense theory number two is that the person that planted the evidence on the socks, for some reason, then immediately called the news media and said, guess what, I just planted some evidence on the socks, or guess what, there's evidence on the socks, and it's going to be Nicole Brown's blood. And that seems to be particularly unreasonable to conclude that the very individual that participated in planting the evidence then called the news media to tell them about that. So under either scenario that the defense wants to pursue, whether the evidence was planted after the leak or before the leak itself does not logically help to establish that evidence was in fact planted, because the person that was responsible under theory number two for planting the evidence would be the least likely individual to want to do anything to make that fact known and perhaps be caught in the process. So I have suggested that none of these three prerequisites can be established. You can't show that it was a leak of DNA test results that in fact occurred. You can't show that the person came from SID. And even if you could show all those things, you still can't logically connect up this so-called leak to the question of evidence planting under any scenario that I can see the defense arguing before this jury. I'd like to get to the other more technical issues, but that would assume that we got over the threshold issue of relevance. I don't know whether the court perhaps would like to divide this up into pieces and decide the issue of relevance first, because then we have some issues involving privilege, hearsay, conclusions and opinion evidence, a variety of technical legal issues that would go to how the defense would try to present this evidence if the court ruled that it was relevant. But I don't know whether the court would choose to, in effect, break up the arguments and decide the issue of relevancy first.
Well, let's look at the spectrum of the evidence that we have here before us. We have, with regards to the sock, we have the testimony of, I recollect it was Detective Looper, that the socks were recovered at his direction because, quote, they were out of place. That's an explanation I've never heard before. We have the offer regarding Mr. McDonald's testimony that blood in the interior of the sock A is blood that was not powdery, but in a form such that it had to have been, it was not transferred into that fiber by powder means. It was a liquid when it got there. We then have the testimony of Dr. Reeders that, in his opinion, the testing done by Roger Martz with regards to the sock is, in his opinion, indicative of the presence of EDTA. Putting those three factors together with the premature claim that RFLP testing shows that Nicole Brown Simpson's blood is on the sock. I mean, that's a pretty plausible offer of proof as far as going further, wouldn't you say? So
No.
you don't think so?
Well, as to the issue of Detective Looper, Your Honor, Detective Looper's testimony that as to him directing people to collect the socks, the court never heard before because it was never relevant to them before. Of course, Your Honor knows that the prosecution on each one of the factors the court has raised has counter arguments, and
Oh,
so I understand, and that is not directly relevant to the court's question. What is relevant is the issue of, is the defense allowed to prove, if they can, that the socks are planted? Certainly.
All right. Here's the thing, though. In the scenario that I just posed, the chain of facts or proffered evidence that I've discussed, and the next link in this is that there's somebody in the police department who knew about this and told somebody in the news media
Who knew about what?
about the fact that there's blood on the socks
So
in a premature fashion.
That's scenario number two. What I've talked about is scenario number two, that a person either planted the evidence, him or herself, or had direct knowledge of this and participated in it, and then decided to disclose it to the news media.
But don't we, from this point, then have to make an inquiry of the news source first as to who the source was before we determine how much further down this line we go?
Well, I'd agree, Your Honor, that if the news people said, I received information from Mrs. Smith, who works for SID, that this evidence was on the socks, a couple of the relevancy hurdles that I articulated would be overcome. Because then we do have, in fact, evidence of a leak, rather than just speculation and conjecture and so on that we have to infer what was said. We do
Mr.
have the
Goldberg,
second...
in making your argument, you should understand that we're not about to conduct this trial by TV news reports.
I would hope so.
But we do have to make inquiry based upon what we've seen here so far of the news media for what their source was.
That's a different issue, Your Honor, and as I was about to say,
Then
I agree with the court.
Depending on that, all of this scenario discussion is really premature before we find out what we get from that other source, what, if anything.
I believe that it has been represented, though, to the court and to both sides. I think we got a letter, I don't know what it was served on the court.
Yes, it was.
From the news organization saying that they would, that they obviously didn't want the witness to testify even to authenticate the tape, but clearly that they would invoke their privilege.
But you are familiar with several cases throughout the country where reporters, despite having identical reporter shield laws, have been forced to divulge sources or face the contempt power of the court. And since it appears this trial may be going on for several months, that could be a significant sanction.
Well, Your Honor, I am not addressing the issue and was not arguing the issue of whether or not the court wants to hold such a hearing and then attempt to get this reporter to divulge their source. That's a separate issue. And obviously, if the answer...
The point I'm making is that before we get to the cross-examination of Michelle Kessler as to news reports, there has to be a little bit more there than what we have now, is the point I'm making.
I'd agree. And I think that the burden is on the proponent of the evidence to get that little bit more in here, however they want to do it.
All right, then procedurally, my understanding is that the news reporter in question has been subpoenaed?
Yes, Your Honor, I believe she has. Step out. Ms. Andy accept service in that. So that happened yesterday. I'm holding out. I'm sure that's the call.
All right. Then I would say this further discussion about scenarios at this point is really premature before we get that other piece of information.
Okay.
Mr. Elma? Let me just cut to the chase. Do you agree procedurally at this point, we perhaps should have a 402 hearing calling the reporter and asking them if they're going to divulge their source, and if not, proceed accordingly?
Your Honor, I think we can make a sufficient showing that the source of this news leak was the SID laboratory without the divulgence of the source by the news reporter.
Okay, how do we do that?
We do it simply by asking Ms. Savage to come in and authenticate the report that was given and to confirm the information which has already been disclosed to this court in the form of a letter addressed to Your Honor from Carol Black, the President and General Manager of KNBC TV. At that time, Ms. Black represented to this court that the news story was based upon, and I'm quoting, individuals knowledgeable about the investigation had told KNBC News personnel that socks with blood on them had been part of the material seized by authorities in Mr. Simpson's house. that DNA testing had been requested to determine whether the blood on the socks matched the blood of one of the victims, and that communications from the testing laboratory had reported a positive correlation. Now, that is their representation of the sources. They
But
then...
is the source knowledgeable? As Mr.
Yes.
Goldberg points out, that could include Mrs. Robertson.
Well, I'll get to that in a moment.
Not
They-
that she's not a credible source, but, I mean,
Yeah.
there's a whole panoply of people
Well,
who
there's
claim to be
there's
knowledgeable.
another element to this, because they go on to indicate that this same source had previously provided reliable information. They come back and they reconfirm, and they say, our sources reconfirm to KNBC News their original statements that the tests had occurred and that the communications had been received. Thus, KNBC's news reports were based on the statements of multiple sources with different avenues of information who KNBC knew had knowledge of the investigation and who had on previous occasions provided accurate information to KNBC. Now, I assume that Tracy Sabrich would also testify that KNBC does not base news reports simply upon lucky guesses or upon crackpots. So we're limiting, at least somewhat, the available pool of sources from whom this information might have emanated. Now, through the testimony of Michelle Kessler, we believe we can establish a chronology that points a very, very reasonable inference of a finger of more than suspicion at the SID laboratory itself, because you have to put this in the context of a chain of events. And that chain of events starts much earlier than September 21st. It starts on September 12th, when Michelle Kessler, as director of the SID laboratory, receives a fax from Cellmark giving DNA results. That faxed report is not even transmitted to the prosecutor, Marcia Clark, until 4 days later, on September 16th. But on September 12th, on the same day that the fax is received by Michelle Kessler, there are news reports, including, I believe, a KNBC news report, reporting the results of those DNA tests. All right, then we're told on September 18th, a PGM subtype of the sock is done, and it turns up results consistent with Nicole Brown Simpson. Now, the question is, who knew of those results? That test was done by Greg Matheson within the SID laboratory. We'd like to ask Michelle Kessler, well, who found out about those PGM results? To whom were those results disseminated? Apparently, the decision was made on September 21st to send the socks out for DNA testing. We would like to know who made that decision and to whom that decision was communicated, because on September 21st, coincidentally, that's the date that the news leak announces DNA results on the sock.
All right, do we have a copy of the fax of September the 12th?
Yes, we do. I believe that was appended to an earlier motion that we filed with the court.
I didn't see it in this round of motions.
I'm sure we can lay our hands on another copy and make a copy of that. We believe that Ms. Kessler would also testify as to the method by which evidence and information of this nature was handled within the SID laboratory, that she would testify that this was a sensitive investigation, that steps were taken so that only those who had a need to know would be informed of information of this nature, and we would like to ascertain just who had a need to know under these circumstances. I believe we can limit the pool of available sources to a very small group of people from whom this information could possibly have emanated, who would have known.
What we have, though, is that this information was just flat out wrong.
Well, the information was wrong only in a couple of minor details, including the detail that the tests had already been done and that the socks had been sent to a particular laboratory. But the discovery...
But in all other respects, it was correct.
Well, it was correct in terms of the discovery, alleged discovery of blood on the socks. It was correct in the
But that was known
attempt...
in August.
Well, it was correct in the attempt to link that blood to Nicole Brown, which would have been only known to those who had access to the PGM subtype results that were achieved on September 18th.
Well, let me ask you this. Do you want to pursue dragging Tracy Savage in here and asking her to divulge or not? Do you want to pursue this other indirect line?
Yes, we do want to pursue bringing Tracy Savage in, but we believe it's not even going to be necessary to require her to divulge the identity of the source. All she has to do is confirm the information that has already been disclosed.
Do you think I'm going to allow playing that news broadcast to the jury as evidence in this case?
Yes, I think you are, and you should.
Under what plausible grounds could I do that?
Well, it's not being offered certainly for the truth of what is asserted in that news broadcast, so it is not hearsay. It is being offered to show the link in the chain with respect to the planting of evidence in this case, Your Honor. We have to put this in the context, as Your Honor has already noted, of other evidence. When I was a prosecutor, I used to love the metaphor of a brick in the wall, and that you can't keep out evidence because it's only a brick and it's not a wall, that all of the inferences and circumstances go together in a circumstantial case to build a wall. We are now engaged, Your Honor, in removing bricks from the wall. We are engaged in the process of creating a reasonable doubt, and that's all we have to do.
Nice analogy. Tell me what your legal basis is for me allowing news broadcasts that are fabrications as evidence.
Because those fabrications emanated from someone in the SID laboratory, which is where we would contend evidence fabrication took place. Now, we have...
Do you think there are a lot of people who have an interest in this case, who have a personal interest in seeming knowledgeable and cultivating media attention, who go out and lie to the news media about this case? Do you think that's a phenomenon
Mr.
that
Goldberg
might have occurred?
suggests that perhaps there are
Thank you.
eavesdroppers and interlopers. Now, if eavesdroppers and interlopers had access to the evidence in this case, that is something we'd like to know about, because the existence of possible eavesdroppers or interlopers may itself create some doubts about the integrity of the evidence and the question of whether evidence was planted. But the fact remains, Your Honor, that we believe we can establish within the SID laboratory, within the very small pool of people who had access to this information, who could reasonably have been the source of this leak, that the leak itself creates an inference that evidence was being fabricated. That somebody would have enough confidence to tell the news that there will be positive DNA results on a sock indicates a high degree of confidence that that's what the results will show. And that confidence could have come from involvement in actually putting that evidence there and knowing in advance that that's precisely the result they're going to get, because they ensured in advance that that would be the result. And we
I
believe
read it
that is not a
correctly. I didn't even
speculative
notice
or
the
unreasonable
typo
inference
until you
in
said
light
it.
of all of the other inferences that we have with respect to the sock. We have the discrepancy in when and where the sock was found. And that evidence isn't relevant just to create some scenario, as Mr. Goldberg suggested, that somebody planted a blank sock.
No, I
What-
dismiss that as...
What that evidence does is suggest to the jury that this sock, as well as other evidence, was not particularly handled with great care, that we cannot trust the evidence and the records of the criminalists who say they collected that sock when we've proven that those records are wrong, that they have the wrong time with respect to when those socks were collected. Then we have discrepancies in terms of when blood was discovered on the socks.
Well, counsel, let's get back to my question. What legal, statutory, case law, other example that any court anywhere in this country has ever allowed a fabricated news report as evidence in a case? Ever?
I'm sure we can come up with cases where news reports have been admitted for a non-hearsay purpose. And that's...
Give me one.
I'll get right to work on that, Your Honor. What we're offering this news report to establish is that the SID laboratory was the only logical source of that information, that the pool of individuals within that laboratory
I understand the argument.
were persons who had access to the evidence and could have participated in the planting of evidence. So we're simply adding or subtracting another brick from the wall that creates that hole of reasonable doubt, that gives this jury a reasonable doubt as to the integrity of the evidence that is being presented in this case. And the news leak is crucial to establishing that additional inference. I mean, you can't, in terms of our obligation of creating reasonable doubt, draw circles around what bricks we can displace from the wall that the prosecution is attempting to build. And this is a very important brick. The brick that suggests that the SID laboratory maintained tight security over the evidence, that the evidence was not available to others, that information about the case was tightly controlled. And here we're rebutting that inference, I think with very persuasive evidence, that there were leaks from that laboratory, and those leaks create doubts about the integrity of this evidence.
All right. So how do you want to proceed at this point?
We would like to proceed by calling Tracy Savage, by asking her to authenticate the news tape, by asking her whether KNBC bases news reports of this nature on lucky guesses or on crackpots, and to confirm the information that was disclosed to this court in the letter of Carol Black, that this information came from a knowledgeable source about the investigation, and that source had given prior information to KNBC, which turned out to be reliable. We would then proceed to call Michelle Kessler to inquire as to who were the persons within the laboratory who had any information about DNA results, who had access to the faxed DNA results on September 12th, who had access to the PGM subtype test done on September 18th, who had knowledge of the decision to send the sock out for DNA testing on September 21st. We believe that will be a very limited pool of possible sources, and that's all we need.
Mr. Cochran, what's the status of your subpoena for Ms. Savage?
Mr. Evans has indicated that she was served, I believe, Tuesday this week through counsel for NBC, and if the court would like, I can make some phone calls if you give us a schedule. They've indicated that she's usually in and around this building, but apparently she is now under subpoena.
All right. When do you want to proceed? I think there's a very necessary step that's missing here.
You've heard Mr. Ullman's arguments. You're the judge. We'd like to proceed as soon as possible, obviously, I'm not sure. Given the schedule, we have Dr. McDonald, President McDonald, but we'll work around that, and we have a short day tomorrow. So you let us know what the schedule, what's appropriate, and we'll work around it.
My recollection is we have to conclude Dr. Reeder's tomorrow morning.
We
You
do.
want to present Mr. McDonald today,
That's
correct? And my recollection is he's from out of town as well, correct?
Yes, they're both from out of town.
All right, let's go with McDonald. When we take our recess, we'll come back at 10:30. We'll start with Mr. McDonald. Counsel, once you make arrangements, I take it, is Kessler your next witness after McDonald and Reeders?
I would think so, yes, Your Honor. With Savage Kessler. Yes, Your Honor.
All right, then let's go Monday with this.
Monday morning, 9 o'clock?
Monday morning, 9 o'clock.
Depending what happens tomorrow, but yes,
But that'll be for the 402 hearing regarding what comes out of Savage.
that'll be fine.
All right.
There is one more matter, I believe, this morning, Your Honor. I served Mr. Cochran with a subpoena ducis tecum. Did the court have an opportunity to see that? I filed it with the court yesterday so that you could take a look.
Yes.
As the interview that was conducted by the DAI, as that little typewritten statement says, the witness, Gretchen Stockdale, confirmed the truth of what was reported in the New York Daily News article on May 13th, indicating that Mr. Simpson had called Ms. Stockdale, saying that he was finally in a place in his life where he's totally unattached with everybody and so forth. So that's information that the prosecution, that tape, which Ms. Stockdale made of that phone conversation, is evidence, which the prosecution has a right to. This witness said that she had only one copy, and she gave that sole copy to Mr. Pavlik, the defense investigator. So we are not trying to use the subpoena process for discovery. We're trying to get evidence which we already know from an independent source exists, and the only copy of which was given to the defense.
Your Honor, our position on this is completely consistent with the position asserted by the prosecution in response to defense subpoenas, and that is that the reciprocal discovery law itself specifically provides that it is to be the exclusive means of obtaining discovery of evidence. And the appropriate way to proceed in this case is by a discovery request. Our position, of course, would be that this is not evidence that we are required to disclose, that it is rebuttal evidence in case this witness is called. It is not evidence of the crime within the meaning of the Meredith case that the defense has any obligation to turn over, and we do not intend to call Gretchen Stockdale as a witness, so there was no obligation under the discovery law to turn this over.
Oh, Your Honor, this is physical evidence that the prosecution has a right to. They can't shield evidence by having a witness give it to them and hide it from the prosecution. The witness did voluntarily interview with us, and she indicated this is where this particular cassette tape went. We're not in the situation of discovery at all, really, with regard to this cassette tape.
All right, so I think what you need to do is file a motion to compel the production of this tape. I agree with Mr. Ullman, the subpoena ducis tecum upon defense counsel is not a mechanism authorized by 1054. All right. All right, let's take a recess for 15, and we'll start with Mr. McDonald. Yes.
I'm informed that among the items of evidence that we'd like to put on today is the videotape and the grand jury testimony of Thano Paradas. And I understand that the prosecution has taken the position that they want to offer some additional statements pursuant to 1202. Our position, and I think Your Honor can rule on it at this time, is that that's appropriate for their rebuttal case, but the admission of this videotape and the grand jury testimony as former testimony does not depend upon the availability or presentation of any impeaching evidence that they would like to present, that can be done in the course of their rebuttal case. We were not allowed to interrupt the presentation of their case in chief by bringing in witnesses that we assert would impeach the credibility of any of their witnesses. We'd like to proceed with our case with the presentation of this evidence, and if they want to offer something to rebut or impeach it, they can do that during their rebuttal case.
All right. Who's going to address that matter for the people?
Your Honor, first of all, I'm not sure that the people were told, maybe Ms. Clark was, that they intended to put on the transcript testimony of Thano Paradas today.
No, we've discussed it
That
as
that was
coming
going,
after McDonald.
that was going to be today.
Not necessarily today, but following McDonald.
Oh, okay. Well, then that might not necessarily be today, I would assume.
Well, we may not finish McDonald today, at the rate we're going.
But at any rate, Your Honor, I did not research the specific issue that counsel has addressed as to the appropriate mechanism in terms of order of proof for dealing with the hearsay declarant. What we do know is that we know that the court has statutory authority to control the order of proof. That we can be positive of. And we also know that if Thano Paradas were to have come into this courtroom, as opposed to having his testimony presented through the transcripts, that Mr. Paradas could be asked about prior inconsistent statements on the witness stand, and therefore those statements could be put in front of the jury immediately during the presentation of that particular witness. Obviously, we can't do that with the hearsay declarant because we're never going to be able to confront him with the prior inconsistent statements. Nevertheless, we are statutorily entitled to call a witness who can testify to those statements. What I would say to the court is that given that the court does have statutory authority to control the manner of proof, and because the court has in effect made a ruling or there has been a finding of unavailability, the prosecution should be able to present those prior inconsistent statements at the same stage in the trial that we would be able to present them if he were here live. That is immediately upon the heels of what would be his direct testimony, the reading of the transcript. Now, the other issue that's raised by what Mr. Ullman just stated to the court is the question of whether or not the grand jury testimony is admissible. That was not subject to both direct and cross-examination, obviously. So I'm not sure that the grand jury testimony, as opposed to the preliminary hearing, is admissible per se, although I'm not certain whether the people would have an objection to that. I'd like the opportunity to take a second look at that, or perhaps another member of our prosecution team to determine whether tactically we would want to make that objection.
All right, we'll take that up at the conclusion of Mr. McDonald's testimony then, whenever that might be. But be prepared to tell me what your position is regarding the grand jury aspect as soon as you can. Let me just make this one observation, though, about order of proof. This witness was available to the prosecution in their case in chief. The testimony by Mr. Paradas could have been presented, his testimony now that his recollection is X, Y, and Z as far as how much blood was collected from Mr. Simpson. And then he could have been, during the direct examination, asked about prior testimony. He could have testified how he was mistaken or whatever the offer might have been. That opportunity was available to the prosecution. They did not avail themselves of that. Any 1202 evidence, assuming that it's admissible, will be restricted to the prosecution's case in rebuttal. All right.
We have not, at this point, received any statements or any offer of proof with respect to 1202, so we're completely in the dark
Well, it
as
could
to whatever it is they're going to offer.
could be rebuttal evidence that they don't have to disclose to you at this point.
Well, if it's
So
rebuttal,
depending on how you want to play this,
if it's rebuttal evidence, then it should await their rebuttal case.
probably should. All right, we'll take.
We did say, and so Your Honor was clear on that day, we did say if we ran out of time, Agent Marks, we would call Mr. Paradas.
Yep, I recollect. But I also said I wanted to see it one more time before we
Sure,
play it.
we'll make it.
My recollection is 8 or 9 minutes. No, we're going to take a recess for 10 minutes. All right, thank you. 10.
Good morning, Your Honor. Just 1 second. I'm asking Mr. Harris to actually get a couple of boards, which are apparently not up here, so I'm going to show him photographs of the boards. Good morning, Your Honor.
Neufeld.
Our next witness is Professor Herbert McDonald, and there are a couple of points I wanted to get out of the way first, Your Honor, in the nature of 402 and in limiting matters. First of all, I think you may recall I mentioned in front of Ms. Clark yesterday that this witness will not be testifying at all to any crime scene reconstruction at Bundy, and that I believe, therefore, that would be beyond the scope of cross-examination, and I wanted to have that issue resolved before I called the witness, because it doesn't go to impeachment, and he's not their witness, he's our witness. So that's the first issue. The second issue, Your Honor, is that, as you know, Professor McDonald conducted a glove shrinkage experiment, and although that may open the door to the prosecution conducting its own glove shrinking experiment with the gloves that they have, I don't believe it opens the door to displaying other photographs that they have or purport to have, and Mr. Simpson wearing leather gloves in different places. One has nothing to do with the other. This experiment is being this experiment is being introduced for a very limited purpose, so I would like a ruling on that. And third, Your Honor, I would ask for a ruling in advance of me calling this witness as to which cases the prosecution would be entitled to bring up on cross-examination. I'm not asking for transcripts now. I'm just asking for certain cases, because Professor McDonald has been involved as an expert witness on behalf of the prosecution and behalf of the defense in many well-known cases throughout the country, and I want to make sure that if other cases are brought up, they're brought up because they are in fact relevant and probative, either directly or as impeachment purposes, and they're not simply brought up to create innuendos about his involvement in one case as opposed to another case because of the name of the victim or the name of the defendant, which would be completely irrelevant in these proceedings. And that's why I'm asking for a ruling in advance of which cases the prosecution intends to go into.
All right.
Thank you.
Ms. Clark?
I don't really understand how counsel can require us to state what we intend to use to impeach a witness who has given us no report, who has given us no indication of what he's going to testify to. We are here in the blind, as the court is well aware. Certain topics have been referred to, that he will address this topic or that topic, telling me nothing of what he intends to say about that topic. And in view of the fact that they have determined it's appropriate to keep us in the blind and not tell us what he intends to testify to, I cannot be in a position to accurately inform them of what I intend to impeach with. That's what I have to say about the cases we intend to use. I don't know. If he would tell me what he was going to say, if counsel had been forthright and candid about what he was going to testify to and what his conclusions would be, I might be in some position to help them, but I can't. With respect to the crime scene at Bundy, again, how do we know what he's going to say? Some comparison to the blood drops at Bundy or something present at that crime scene might be relevant impeachment, given some conclusions he makes about what he sees at Rockingham. And until we hear that, we don't know. This is what they have bought into by failing to tell us or give us any reports as to his conclusions. How can I know what I'm going to use to impeach or ask to use to impeach? With respect to the glove photographs, any, I think, photograph or any evidence that is relevant to impeach the experiment that they undertook to conduct is, I think, fair game. They have undertaken an experiment in which they took a brand new pair of gloves that fit Mr. McDonald very differently than the gloves fit Mr. Simpson when they were first purchased for him by Nicole. And all of the differences that are accounted for by the fact that new gloves were used in their experiment and old gloves were obviously the ones used in the crime should obviously be fair impeachment, not to mention photographs that may depict the conditions that those gloves were subjected to. Counsel can't have it both ways. You want to come in and use an experiment that is so easily impeached by the dissimilarity of the conditions, then this is what happens. The dissimilarity of the conditions should be brought forth to show the jury that this is worthy of no weight. Can't have it both ways, though, and try to insulate yourself from cross-examination, which is basically what counsel is asking to do. We want to put this evidence on, but you can't impeach us.
Josh just sent me porn on my phone. Pecan pie recipe using a graham cracker crust. Oh, Josh, spicy.
Not the way the law works. So that is our response. I think that any relevant impeachment should be allowed, but until we know what he says, we don't know what that is. May I also address the court on another matter, and that is the expert has given us no report on his conclusions concerning what he saw at Rockingham, what he saw in the Bronco photographs. I think the only notes we even have from him are the glove drying experiment. That's the only thing that they intend to present from him that we have some kind of written material on, and the observations of sake. So really it sounds to me like the bulk of his testimony is unreported and unnoted in any document. In light of that fact, Your Honor, the people have no chance to prepare. And in order for the people to have the right to a fair trial and to be prepared to adequately cross-examine and confront the witness, I think I'm asking the court leave under the old laws. This is not even under the new statutory discovery laws, which compel counsel to produce discovery. Even under the old laws, when an expert testified and gave late discovery of a report or no report, the people would be entitled to some time to prepare for cross-examination and not be required to stand up and cross-examine immediately after direct was concluded without having had some adequate opportunity.
But isn't that an issue we need to address after we've heard the direct examination to see what the extent is? I mean, who knows? Mr. McDonald may present evidence that you're completely adequately equipped to address.
Well, given the fact that two of the major areas they intend to address have no reports or notes, I can't imagine that being the case, but I get that the court wants us to wait on this.
Well, you're asking me to make a premature judgment as to what's going to be there. It may be something so simple and logical to deal with that even I could do it.
I don't share the court's, the humbleness of the court's self-characterization, but we'll wait and see.
Let's wait and see.
All right.
All right, Mr. Neufeld, in answer to your questions, without hearing the testimony, it's hard for me to circumscribe or give you a ruling with regards to the scope of cross-examination. With regards to Bundy, I agree under normal circumstances, if you don't present any testimony as to any evidence at Bundy, then that's probably not fair game. But if there is a comparison, for example, between blood drops at Rockingham and their appearance versus the blood drops at Bundy, and if there's any difference, if that becomes relevant, that might be fair game. I don't know. With regards to the glove shrinkage, you've asked me to some concern about pictures of the defendant wearing gloves. You know, as we pointed out in our discussions about gloves, you know, the experiment was conducted on a new pair of gloves. There are pictures of Mr. Simpson that the prosecution has alluded to wearing gloves in winter weather, which may be one of the factors, you know, snow, moisture may be one of the things you have to take into consideration as to whether or not gloves are going to shrink over time. I don't know.
Blood.
But before that is broached in cross-examination, I'm going to ask Ms. Clark as to any cross-examination regarding the Bundy crime scene, any photographs of the defendant wearing gloves, and any transcripts that you might have on other cases that Mr. McDonald has testified to. I want you to notify the court and approach so that we can examine that before we go any further.
All right, just two things very briefly.
Yes.
One is, as you know, there were reports turned over about the bulk of what Professor McDonald will be testifying to. And I conveyed to the court and to the prosecution that that is the reality of what you're about to hear, and I assure the court once again that it is that. And for the people to make this assertion that they've had no reports and no notes really isn't a fair statement.
Well, counsel, as I indicated to you, any request for continuance for preparation of cross-examination is after I've heard the direct, and let's see what it is.
We have a brief sidebar, Your Honor.
For what purpose?
I would just like to bring up one matter with the court, which I'd like to do a sidebar if possible.
Let the record reflect that we've now been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. My apologies
About
for
time.
having kept you waiting upstairs so long. We had a number of motions to take care of out of your presence. We did conclude most of them, and we'll proceed with the next witness. Mr. Neufeld, you may call the defense next witness.
Principal Herbert McDonald.
Raise your right hand, please. Do you solemnly swear that the testimony you may give in class now being before this court will be the truth, the whole truth, and nothing but the truth, so help you God? I do, so help me God. Please have a seat and you witness stand and state and swear your first and last names for the record.
Chocolate chip cookie.
My first name is Herbert. The last name is MacDonald, capital M-A-C, capital D-O-N-E-L-L.
Mr. Neufeld.
I knew a car with that name once.
Sir, could you, I guess you already gave your name, could you please tell the ladies and gentlemen of the jury where you live, sir?
I live in upstate New York, in Corning, New York by name.
And could you please tell them what is your occupation?
I'm director of the Laboratory of Forensic Science, which is an independent laboratory available to both prosecution and defense in criminal and civil cases.
This is going to
But
be
I have been
boring.
involved in cases other than civil and criminal, mainly private.
Do you also hold any other business titles, sir?
Yes, I'm president of what is called McDonald Associates Incorporated, a company that manufactures fingerprint equipment that I invented some years ago.
Do you have a degree from a recognized university or college, sir?
Yes, I have a Master of Science from the University of Rhode Island, a major in analytical chemistry, and a minor in physics, a Bachelor of Arts degree from Alfred University in upstate New York, with a major in chemistry and a minor in mathematics.
And do you have any other formal education beyond those degrees, sir?
Yes, I have taken many courses under the state municipal police training councils, such as Pennsylvania and New York, and also I took a 10-month program under the Department of Attorney General of the state of Rhode Island, dealing with what was then called criminalistics, and the course involved mainly physical evidence.
Have you conducted any teaching on a college or university level?
Yes, I was professor of chemistry and head of the department of a small Midwest college in Milton, Wisconsin for 3 years. And other than graduate work, I began teaching at Corning Community College, a 2-year school under the State University of New York, from 1960 to 1992, with a 5-year sabbatical in there off and on. I also taught at a 4-year school in upstate New York, Elmira College. That was from 1972 to 1983.
Yum.
At that institution, I
That
taught many
sounds
forensic
delicious,
courses,
Malta.
10 specifically.
So in all, you said you started teaching in 1951 when you were
Yes.
the chairman of the department at Milton College?
Yes.
And are you still teaching today, sir?
I'm teaching, but not with any college or university. I run institutes, specialized schools that are usually 1 week in duration, and conduct many workshops and seminars of 1, 2, and 3, 4-day duration. But I'm not currently affiliated with any particular college.
All right, we'll come back to that other institute later, sir, but you mentioned that you began in 1951 as a professor, head of the
goody.
department at Milton College, and you finished your last professorship.
No.
Was in what year, sir?
1992.
Okay, so you were teaching on and off for approximately how many years?
I have a Washington
35
County,
years,
Georgia
depending
case
on whether
going
you
on, John.
deduct these sabbaticals or not.
All right,
And
even though you're
I'm
not
getting the
technically teaching
verdict
right now,
any second.
having taught for 40 years as a professor,
So I
do
gotta
people still
get
address you as
recording.
professor?
Yes, they.
Sustained. Praise
So, in this case, I don't know if I'm going to show it on this channel because it's a bit boring. It is a bit boring. I have a different channel for boring trials. Not court disorder, a different channel. But in this case, they tased this guy. The police tased this guy like something crazy, like 57 times. And he died in Georgia. So there's 4 police officers, 5 police officers, something like that, on stand for murder. And they brought in a whole bunch of doctors saying that the taser couldn't have killed him. It's impossible. The tasers don't kill. The electricity going through him didn't give him a heart attack. He had a heart attack because of other reasons. He was going to have a heart attack anyway. It had nothing to do with the tasers. That's what their experts got up there and said. Like, they didn't just tase him. They tased him like over and over while he was handcuffed, or at least partially handcuffed.
Given the duration of time that you actually were a professor, since 1951, as a result of that, do people refer to you as professor?
Yes, quite frequently they do. I referred to as doctor many times. I do not have a doctor's degree, but I receive this title quite often, and it's embarrassing to either correct the person or ignore it. It's a difficult choice sometimes.
Professor McDonald, what experience have you had in the field of scientific crime investigation?
Well, when I went to the University of Rhode Island in 1954, I worked for 2 years in the State Crime Laboratory in Kingston. It was located at the University of Rhode Island. I worked with Dr. Harrison, who was director of the crime lab, and my master's thesis was on forensic applications of bloodstain pattern and typing and so on. Dr. Harrison conducted the courses in criminalistics, and in the process of taking the courses, we very often worked on cases together around the area of the state of Rhode Island. In 1957, I began consulting on a more frequent basis and have done so ever since.
And I take it you belong to a number of professional societies.
Yes, I do, quite.
And I don't want you to list them all, sir, but are there any societies in particular which you feel are relevant to the testimony you're about to give in this case?
Well, I'm a fellow in the American Academy of Forensic Sciences. I have been for over 31 years, a member several years before that. I am a member of the International Association of Bloodstain Pattern Analysts.
Could you please tell the ladies and gentlemen of the jury what that second association is?
That's an association that was founded to encourage people who have studied the subject of interpreting bloodstain patterns, not serology, but the geometry of bloodstains. It was founded in 1983 at the request of many of my former students to have additional training. So we conducted an advanced school, and during the first advanced school in November 1983, this association was founded. It now has anywhere from 250 to 400 members. I'm not sure the total because some drop in and some drop out, and the ones that don't pay their dues aren't on the roster, so it's at least 250.
And do you have a special title in regards to the International Association of Bloodstain Pattern Analysts?
Yes, I'm the historian. I have been since the the organization was founded. I'm also classified as a distinguished member of that association.
What does it mean to be a distinguished member of that association, sir?
It's recognized by your peers as having made substantial contributions to the subject or discipline of interpreting bloodstain patterns.
Are there any other people in this 200 to 400 member International Association of Bloodstain Analysts who have the title of distinguished member?
No, not at the present time.
Oh, wow, guys. This is going to be riveting for tomorrow. Tomorrow morning, we are going to be glued to our tablet, our monitor, our TV, our phone, whatever you watch on. We're going to forget to eat, sleep, breathe, blink. We're going to be riveted. All right. I hope you guys have a great day. I hope you get a lot done. I hope you fall asleep so tired. And I will talk to you in the morning. Bye, guys. Behave.